dia da minha nova vida. Nesta sexta-feira, dia que o Senhor fez, eu quero convidar você a agradecer a Deus pelo dia que Ele nos dá. O dia que Ele nos abençoa na manhã de hoje, com a sua misericórdia sendo sempre renovada. E quero destacar aqui com vocês, nesse breve momento de meditação, um salmo, que é o Salmo 118, versículos 1 a 9, que diz assim: Rendei graças ao Senhor, porque Ele é bom, porque a sua misericórdia dura para sempre. Diga, pois, Israel, sim, a sua misericórdia dura para sempre. Diga, pois, a casa de Arão, sim, a sua misericórdia dura para sempre. Digam, pois, os que temem ao Senhor, sim, a sua misericórdia dura para sempre. Misericórdia é a forma como Deus nos trata, é a forma como Deus cuida de nós. Ele olha para nós com o coração, por isso misericórdia, com o coração de quem entende as nossas necessidades. E o texto aqui, nesses 4 primeiros versículos, nos conclamam a dizer sim, a sua misericórdia dura para sempre. O profeta diz que as misericórdias do Senhor renovam-se manhã após manhã, porque grande é a sua fidelidade. O texto do Salmo continua. Depois de falar do tratamento de Deus, como ele nos trata com misericórdia, agora o salmista fala de como o Senhor cuida de nós. Diz assim o texto: Em meio à tribulação, invoquei o Senhor, e o Senhor me ouviu e me deu folga. O Senhor está comigo, não temerei. Que me poderá fazer o homem? O Senhor está comigo entre os que me ajudam, por isso verei cumprido o meu desejo. Melhor é buscar refúgio no Senhor do que confiar no homem. Melhor é buscar refúgio no Senhor do que confiar em príncipes. Em meio às nossas tribulações, diz o texto, quando nós invocamos ao Senhor e buscamos a sua presença, ele nos ouve e nos dá da sua bênção e da sua misericórdia. Portanto, nesta manhã, damos as boas-vindas a todos e todas aqui presentes em nome da capelania, da chancelaria do Mackenzie, à professora Marlena, nossa querida convidada, aos demais professores e professoras, na certeza de que, como diz o salmista, este é o dia que o Senhor fez. Regozijemo-nos e alegremo-nos nele. Assim que Deus abençoe este momento de palestra, o momento acadêmico importantíssimo para o desenvolvimento dos nossos alunos e alunas, a alegria em termos pessoas, professores e professoras de alto gabarito aqui entre nós, mas, sobretudo, a certeza de que o Senhor Deus está conosco, está à nossa frente, nos amparando e tratando-nos também a nós com a sua misericórdia. Assim que Deus abençoe. Sextou, e sextou porque é dia que o Senhor Deus fez. Nos alegramos e regozijamos nesse dia. Deus abençoe, um bom evento a todos e a todas. Amém. Obrigado.
Muito obrigado pelas sábias palavras, reverendo. Muito gratificante escutar o senhor, como sempre. Gostaria de convidar agora para a comissão da mesa organizadora o professor José Geraldo Romanello Bueno.
A todos, bom dia. Muito obrigado pela deferência de poder ser um dos organizadores desse congresso. I will speak in English later on, Marlena, ok? Então, eu gostaria de agradecer imensamente a quem confiou em relação à organização desse evento.
O professor desligou seu microfone.
Desculpe, a professora Marlena é uma pessoa muito querida, já a conheço há anos, já nos encontramos várias vezes na Polônia, e ela é uma das pessoas, uma das professoras mais famosas, né, sobre direito de moda no mundo. Inclusive, nesse momento, ela não está na Polônia, ela está na Austrália, em Melbourne. Muito bem. A professora Marlena, ela é professora associada da Faculdade de Direito e Administração da Universidade da Silésia, em Katowice, na Polônia. E é uma das pessoas com maior destaque, maior currículo em direito de moda. Então, a quem for assistir, com certeza vai ter o prazer de ouvir. I will say in English now, Professor Malena. I said that I am very happy to be one of the organizers of this law, text, and context, the influence of German theories. I presented you as an associate professor of the Faculty of Law and Administration of the University of Silesia in Katowice, Poland. Everybody knows that you are very famous here in Brazil. Talking some time ago with the head of the Department of Civil Law, I talked about you, and she said, "Oh, Professor Malena is very famous. She had been here in Brazil once, so I'm glad also that you will come to Brazil next December to speak in Rio de Janeiro." So I also said that I know you a long time ago, and we met in Poland many times. So that's why we invited you to do this amazing conference. So thank you very much for your attention and availability to be here with us. Thank you.
Thank you, Professor Romanello. If I may speak now, but it looks that way. Before I start, I wanted to acknowledge the invitation, and also I truly admit that this is a real pleasure and also honor to be here with you. Hopefully, I can also add a few curious things from my ground. And as I will be referring to fashion as a matter of fact, but also to the German perspective, and will familiarize you with some of the German ideas in the doctrine. To start with, before I jump over to my presentation, because as I also understand, my speech is going to be translated, if I get this right. So usually I just talk off the top of my head, but this time I have my notes to really keep to my presentation. But before I start, again, I wanted to pass my warm welcome, actually now from Melbourne in Australia, where I'm a student again, striving for my MBA. But apart from that, as you know, I'm a lawyer, I'm an advocate, and also a true fashion lover. So after my habilitation, I decided to put more emphasis on fashion and fashion law, and also on business. I mean, fashion business here, which is also quite specific. Before it was 2019, as we have established the Center for Design, Fashion and Advertisement Law at the University of Silesia, really only planning to do some research and then also publish a few books, maybe papers, and organize conferences. And you can read more about us at Law in Style, edu.pl. But to my absolute, I would say, astonishment, I discovered that this center that we have established is the only one in Europe. I didn't really compare it against the rest of the world, especially Brazil or United States of America. But this is definitely the leading center, interdisciplinary center in Europe. And therefore, also, I would like to take this chance and invite you to participate in our conferences as well, but also get in touch with us, maybe become our members and with regard to research and papers and books. And we also have our own legal publishing house, which is actually a big help as well. And on top of this, I just wanted to acknowledge a big scholarly friendship, if I may call it that way, between our university and the center and Mackenzie University, and especially Professor José Romanello, who is truly amazing and very understanding. And this cooperation has been going on for a good many years now. So thank you for that so much. Here's our topic today that I will present from Professor Pawełczyk, Mirosław Pawełczyk, and myself. And Professor kindly excuses himself as he was busy in court today. It was like last notice yesterday, so he had to go to court. And however, the research is a joint research, so you won't miss out by not having him. Therefore, as planned, the topic is copyrightability of fashion goods and some business insights under German law. To start with, I wanted to apologize for not including any pictures. I mean, at least not pictures that are highly relevant for our cases. As we are all lawyers here, we know that courts not always upload or include pictures, especially in copyright law. And I believe that this is something that should be done more often. And especially if you go to the US Copyright Office, all these decisions contain a lot of pictures, which is truly very helpful. And also, I dare say, there's lots of legal cases in France and in the Netherlands that are also aided with lots of pictures, as also these cases refer to, I would even say, very prominent or famous examples of design and fashion itself. Therefore, as talking about the German perspective and German doctrine, it would be rather very legal with a very limited number of pictures. Therefore, as it comes to fashion design, German copyright protection is conditioned on the premise of personal spiritual creation. So as some of you here speak German, that would be persönliche geistige Schöpfung, which all by itself sounds pretty nicely, but is also translated to own intellectual creation. And this own intellectual creation, quote unquote, that is a European concept itself. Here, if you need more guidance, that is paragraph 2, section 2 of Urhebergesetz, which is German copyright law. And here, according to according to one of the sections of this paragraph 2, which is section 1, and especially number 4, copyright law protects artistic works, and excuse me, it's okay. Artistic works, including works of architecture and of applied arts, and drafts of such works. So if we look for protection for fashion, that's the major part of the listing of different works that we look for. And it would include not only fashion design as we know it, like dresses and trousers, jackets, but that would also be fashion sketches, fashion pictures as such. And here just one side note, there is actually only one legal regulation in Europe, which is French, obviously, and they do have an explicit reference to haute couture, which is high fashion, in their legal text, in the definition of a work of authorship. And so here, when it comes to Germany, though, the German courts have actually German courts have exerted some influence on this interpretation of aforementioned paragraph 2, section 2 of this Urheberrechtsgesetz to interpret this as referring to a creation of individual character whose aesthetic content is of such a level that in the understanding of artistic circles and of people that are reasonably familiar with artistic views, one can truly speak of artistic achievement. And it is believed that aesthetic effect of a design can only justify copyright protection if it is based on an artistic achievement and also is expressed in a physical form. And here another comment from my side, this is a truly high threshold when it comes to copyright protection for fashion goods. And by this requirement of artistic achievement, it is way higher compared to many other regulations across whole Europe, including France, Netherlands, Spain, Poland, Austria. I know of just one regulation that is above German one when it comes to requirements, and that is Italian. And so for copyright protection of works of applied art and fine arts, as well as for all other types of work, a design level that is not too low would be required here, with also some extra notes, footnotes, as you can see, but I can also upload or share my presentation later if you need it. And so let me move on to one of most famous cases in German law, which is Geburtstagszug. So it's like a birthday train. So it is important to note that until that case, the level of originality required from works of applied art was higher than for other kinds of work. And that was a theory of Zwei-Stufen-Test. So it's like two-level sort of test. Based on an assumption that in the first place we double check whether the premise of originality is met, and then on top of that we put that premise of artistic achievement with regard to fashion. So it is also important to note, maybe I have not stressed this before, but if we had different kinds of works, let's say pictures or music, this requirement would not be in this place. So this was justified by the perception of the intersection of industrial design and copyright protection, as these two regimes of protection are believed to be of the same character, but pertaining to different levels of creativity. And some of you that are in intellectual property obviously know the issue that we have. And for those that are not familiar, I would just explain briefly that this is an ongoing fight between copyright law and industrial property law across the whole Europe, as we struggle trying to understand whether copyright law and industrial design law, or let's say that is patent design under American law, if you will, whether these intersect somehow, are these exactly the same, or are these different? I will not explore that, but just a side note here. And then what is important, the theory of kleine Münze is not applicable to works of applied art. And again, another German, theory, kleine Münze. So this is a theory that pertains to the very the most lowest, so to speak, level of creativity that would still benefit from the copyright protection. So that is, let's say, the minimis concept. So again, very specific to German understanding of copyright law. And so that's one thing. Here's some reference also to Coco Chanel that was used in the German doctrine as an example of a threshold, how and like how to differentiate between different levels of protection or non-protection. So here we have the very famous Coco Chanel's women's suit, and it was at least believed for a long time in German law that copyright protection can be granted to a specific form, but not to a concept as such. Obviously, there is again a fight to understand what is the border between these two, the line that disconnects these two. So whereas a particular Coco Chanel suit does fulfill obligations of originality, and it might be eligible for copyright protection, a general idea of Coco Chanel suit would fall outside of any protection. So as great as it sounds on paper and in theory, that is quite an issue. So if we look at any stores of of lower standards, so to speak, like Zara or Ersay or anything else that mimics and copies these patterns, that's a big business question, because it all goes down to money, revenue, and actually to performance, the business performance. So in the Bundesgerichtshof case, which is the Supreme Court in Germany, in the case that was named as Mode Neuheit, it was generally admitted that protection is usually possible for the period of publication season, after which there is a generally freedom of imitation, which is a so-called Nachahmungsfreiheit. Nachahmungsfreiheit. So again, freedom of imitation. However, if an individual case does not concern a seasonal fashion product, again, it can be claimed that it does enjoy protection that is extended beyond one or more seasons. And those of you that are also advocates, attorneys at law, and all these practical minds, obviously it opens a can of worms, as I wouldn't even myself know how to differentiate between seasonal fashion pattern and not seasonal fashion pattern. Is it so that that patterns may change or not? And then what is truly amazing is that as Bundesgerichtshof created a concept or even a rule, you won't find it in the German law anywhere across Urheberrechtsgesetz. So this is quite intriguing, I would say, because we are not case law countries. We are civil law countries based on interpretation of our statutes. So I find it quite far-reaching, not to say even bold, of Supreme Court to believe they have this capacity to truly change a letter of law. So for a very long time, the German standpoint, meaning mostly theory on fashion design, was that it could be qualified as work of applied arts and therefore enjoy copyright protection. But still in practice, in court, most of the time, it was really hard to prove essential modicum of originality, and it was really hard to exercise any copyright protection. And here was one quite exceptional case regarding a dress. I'm sorry, I don't have a picture. I haven't even seen the case myself, doing all the research for a good many years. So it's also so bad many courts don't even keep these pictures anymore. Again, it's different from country to country, but it's not always in the files. So there was a case that was adjudicated in Leipzig by the district court in 2002, and it was known for actually providing protection for fashion design. Here it was noted, however, that the design was outstanding, and it was absolutely more that something that meets originality criterion. So it went totally beyond any requirements from Article 2 of the copyright law. And still what's important here is that it was accepted in the German jurisprudence that it doesn't really matter whether it is haute couture, so the high fashion, or is it prêt-à-porter, which German call Confection. I don't know about Portuguese Brazilian language, but that is also something that we have in Polish, which is confekcja, so to speak. And all these are eligible for copyright protection. So very likely would be even fast fashion. However, again, to prove it is a totally different story. So moving on to another case that I was doing my research on was a mantle model case. So this is a code model. Here the court made clear that mass production is not excluded as such, and that originality can be absolutely experienced. This very, I would say, individual stamp of personality can be injected or can be imprinted on the model of fashion design. Here we call it in the German literature as individuelle Gestaltung. So it's like individual creation. So it's all the same whether that's a stamp of personality or on intellectual or individual creation. it was actually noticed that originality or individuality can arise through new cuts of lines or a creative combination of elements. However, if they occur individually, they would only be part of a public domain. So here's another concept that is quite simple. It's actually Polish, but it's well fitted here. We call it arrangement, choice, selection. Yeah, arrangement, selection, choice, if you will. And again, if there is room to exercise all these, very likely it will be individual, but again it is about a number of all these individual choices, selections put all together in one place. And here this one place would be obviously fashion design, before specific singular improvements or solutions or even aesthetic elements would not be considered copyrightable, and would also not make the model itself copyrightable. Moving on to next case, that is a Gipure Spitze case. So it's like a Gipure lace. So apparently something a little bit more, I would say, artistic in some sort of way. It was noted that the prerequisite is that it is a new fashion release that is above average and whose overall impression is characterized by individual aesthetic design features. Models with classic elements or classic lines are no exception because fashion is mainly based on what is already known. It was also observed that excessive demands are not to be made, so it can be enough for copyright protection for a shirt, dress, if it is a tasteful dress in terms of style and color that are out of the ordinary. And so that's one of quite flagship cases, right? And then design. All right, so here, I'm sorry, I'm a prerequisite. So yes. And here, moving on to another quote from Gipure Spitze. I will also refer to this hemmed blues and Clyde case. So that's actually what I already said before, as I see very tiny letters here in my Teams. So I would like to make clear that that is actually the case that I was referring to a minute ago. So that was this model of a shirt dress. I was really having trouble translating this shirt dress concept to English, as English as a language is quite limited in a choice of words. So in Polish, for instance, I don't know about Brazilian language, but in Polish we have a specific name for this sort of dress, which is like women obviously know what it is. It's like a dress. But it looks like a shirt mostly with a belt or something like that. Actually, that's what I'm wearing right now. That's it. And we call it szmizierka in Polish. So just, I would say a fashion related comment here. So it is important because as simple as that, a shirt seems to be quite simple, whether shirt or shirt dress, still in this particular case, the court acknowledged it was capable of protection, and here was also the point was that it was it was pleated. That was a pleated skirt and also a large colored checked pattern that in German is called Karo-Muster. So there was a ground that there's a combination of elements, and again it could benefit from protection. And again, coming back to Gebührspitze case, because that was also quoted in this one. So the design elements used in the models. Yes, as you can see it here in my slide, this is the respective cut of the models, the eyelet embroidery, the guipure lace and its motifs, as well as the textile bows are already known in themselves and widespread in the field of underwear, so that they alone are not able to justify an individual aesthetic effect. The overall effect conveyed by the concrete combination of the designing elements does not reach the level of artistic individual creation. It is by no means so original that the special perspective and individual creative power of its creator would be expressed in it. So as you can see, it is not that simple though to invoke copyright protection, which is quite on contrary compared to French law. In French courts, nearly anything goes. If you substantiate your grounds and you also include expert opinions and provide a very specific explanation of your vision of this particular model, I would say it is so easy to acquire protection, and not necessarily in Germany. So moving on to another case, that was Brombeermuster, that is blackberry pattern. That actually goes back to 1983. It was noted that a so-called individually stamped creation, if you will, comes into existence when it can be proved that the content is of such an aesthetic quality that it can be discussed in terms of artistic effort. So really going back to what I have stated right in the beginning of my talk today, and here's quite interesting legal concept to it, which is individuell geprägte Schöpfung, which is translated into individually stamped creation. And sandal case. Therefore, as noted in the German literature that I was studying with professor for quite a long time, actually the jurisprudence, so the case law, is changing in Germany, and they somehow depart from reasonably high threshold of originality, which means that it is being lowered. So this artistic effort that I'm stressing all this time is slowly abandoned and put aside. It is also argued that works of applied art are subject to the same examination, so to speak, assessment, if you will, as any other work, such as would that be pure art, but also literature or music. And quite recently, because in March 2022, so this year, really a couple months ago, there was a decision coming from one of German courts regarding sandals. And in this court, a general idea was given as to the limits of copyright protection of fashion design in German law. I will discuss it briefly in a minute. So here the focus was not primarily on individual design elements, but actually on the overall impression that is conveyed to the viewer. And here, this second bit, that is overall impression, that actually rings a bell from my perspective, at least, because this overall impression, that is a theoretical concept or doctrinal concept used for a good many years in Benelux countries, that is Belgium and the Netherlands, that we studied. Yeah, this overall impression, that is quite an important one. And again, there's lots of a discussion in the literature going on whether overall impression is compatible with any other, I would say, copyrightability approach, which I mentioned before, as on intellectual creation or stamp of personality or selection, arrangement and choice, etc. But again, it's as we are all lawyers here, I believe we can agree that at some point it really comes down to words, like how we understand words and how we interpret them. How we interpret them, and what do you really want to establish, and what's the bottom line. And before I move on to this case, that is Sandal case, I have a feeling that we all as lawyers in practice, right? I mean, in court or in the legal office, from the get-go, we have a feeling or a hunch where we want to go with our interpretations, and we follow our heart, our feelings, and when we look, we search for ideas and concepts in the legal theory that substantiate our inner gut, so to speak. So the bottom line, before I even conclude, is that as many theories, just one actually understanding of copyright law is very much in place, with quite a few, I would say, exceptions, but I'm just talking about the mainstream. All right, so here the Sandal case. So that was a case decided on the 3rd of March 2022 by a district court in Cologne, Köln, if you will. And here the court attempted to draw a bigger picture of how copyright should be applied to works of fashion. So first off, it acknowledged European Union jurisprudence, emphasizing that national courts are competent to assess the level of design and the quality of work, and pointed which are points which are decisive for the copyright protection of works of applied art. In any case, the national courts, even though a uniform EU-wide definition of authorship and creativity is quite recognized, have a comprehensive scope of assessment when fitting the definition of a work of authorship to quite different individual types of work. It is in line with autonomous interpretation of a concept of a work of authorship. If still national courts are allowed to exercise discretion, and obviously here European Court, which is CJEU, leaves it up to national courts. And here I quoted from Barodi that mentioned or noted that the existence of a creation or individuality and originality cannot be deduced solely from objective properties of the respective work. Rather, these characteristics are to be considered based on their relation to the concrete creative process. And the work-creator relationship cannot be adequately grasped either from one-sided view of an author or from analysis of a work alone. Rather, what is decisive is the rules according to which the author of a certain work worked, whereas it is relevant whether he was aware of it. Only when there is no existing rules specifying how creator of a product has to manufacture it in a specific area, for example, using learned processing techniques and design rules, there is no longer any freedom of design, with the result that the development of individuality is then no longer possible, even if a product that has been manufactured to perfection by hand is new and unique and could therefore definitely claim copyright protection. The purely manual or routine performance does not bear the stamp of creativity, individuality, no matter how solid the professional it may be. However, the manufacturer must also fill out the existing scope for design with his own creative decisions in order to become the author. And that means that the creative individuality is not a product of rules, but rather a rule for judging of a product, and it must be judged case by case. And moving on to this case, the court stressed that the creative process, again, must be then analyzed to determine whether the originator only oriented himself to what was given and did not fill the leeway with his own decisions. If it can be ruled out that a designer worked completely according to given rules, it can be concluded that he made something that is creative decision on his own, right, to a certain extent. Then there is a assumption that he actually used the given creative freedom to protect intellectual product. According to this, the claiming author regularly fulfills his obligation to demonstrate the predictability of his work and to make it credible by submitting a copy of a work and presenting its special features. It also pointed that if a person sued for copyright infringement defends himself with the objection that the work in dispute is not protectable or that the scope of protection is restricted because the author has resorted to previously known designs, the author must explain and prove the existence of existence and appearance of such a design. And then it was also further noted that in accordance with these principles, the disputed sandals B and H are protected by copyright. Here actually was looking for any companies in Germany that produce such sandals, but by any means of my investigation, I couldn't really identify these. So I couldn't include any pictures as much as I really wanted to see these sandals. And here the court has experimented with certain materials and design elements and combined them with each other in such a way that the result has a creative character. This applies regardless of the fact that some of these design elements were already known and found in sandals models from other manufacturers, because the originality of the design revised by LC, that's company, lies in their uniform combination. In doing so, he distanced himself sufficiently from the form of representation for sandal models that existed, were customary and well known in his creative field, and made artistic designs that went beyond the form dictated by the function, and the other sandal models raised by the defendant, which are said to oppose the predictability of models B and H, illustrate that there is a wide range of design leeway in the field of sandals and numerous possibilities for filling them. And therefore, LC has found its own rules for sandal design and implemented them in these models, that is B and H. And obviously I will keep looking for these for the files mostly, and I will also address this with the court where it was discussed, when it was decided, that is Köln. However, as of now, I don't have any pictures representing these sandals. I can only assume, because what can be creative in a sandal unless this is really good, cheap Prada, Valentino? So we can imagine something like it's like very quote unquote hoity-toity and very aesthetic, and it's like something that goes beyond a mere function of a sandal. But a sandal, as minimalist as shoe as it can be, I believe there was not really so much to it. Therefore, my assumption here is that the jurisprudence is really taking a turn, and is also changing, and the change is about lowering of the protection requirements. Therefore, more protection for more products, regardless of aesthetic value or aesthetic vision, or any sort of idea that is conveyed to a receiver, so to speak, or the buyer, the consumer himself. So I believe that would actually be the closing slide of my presentation, just to remark that it is only the Italian law in Europe that has got very high standards for copyright protection, meaning that they would not acknowledge something copyrightable without artistic value, but with one major difference, that is in the Italian copyright law, we do have that stated in the letter of law, in the legal act itself. So it's about text, about how you read the text, how you interpret the text. But here we had I would say a string of cases in Germany that that were that actually that were decided, I would say, evidently against or contrary to the letter of law, even though it was acknowledged this way in the jurisprudence. And here, obviously, I'm not supposed to talk about American law, which I totally love in a way, but including some of the doctrines from the US, also. I would like to say that also the United States of America is another country that sets all these requirements very, very high. as the protection of something that is practical and not just artistic or just intellectual, solely intellectual. Therefore, I would actually say thank you as of now, and dziękuję, that will be in Polish, and obrigada. And again, this is me and my contacts here in this extra slide. Therefore, if you'd like to connect, get in touch, or get involved, we welcome any sort of input, and I'm always very happy to collaborate with Brazil. And as I was saying before, I was learning Portuguese Brazilian, yeah, that's but that was in the pandemic. But now, as I'm done with with some of my exams here, and I have my summertime break, I'm getting back to my Brazilian classes. So hopefully at some point I'll just have my presentation in Brazilian, and good enough if I can read it so that you don't need to translate it. And that will be so much fun for myself. I thank you so much. Hopefully my topic was not too boring for you, and hopefully I was just spot on regarding also all the topics related to German jurisprudence. I didn't really touch on Kant or Savigny or Hegel, as we do study them harshly in our legal school, and we are very thankful to these professors and philosophers, as all these premises, even in Polish law, were established based on these philosophers. But I believe that a good many theoretical concepts that I have introduced is already a lot, and I promise to keep it, to dive deeper for the next time. Thank you.
Thank you, professor. Professora Nora, eu gostaria de dizer algumas palavras.
Thank you, Danielle. Thanks to everybody. I am here in the capacity as a mediator, and I have agreed with my colleague, Professor Francesca, that she will start, and then I can go over. I have some comments, of course, and so I wonder if Professor Francesca would open here with some words, and we'll conduct this mediation session, please.
Hi, good morning. Nice to meet you, Marlena. My English is very limited, so I would like to speak in Portuguese very slow. Yeah, I think we can communicate, okay?
Of course, Francesca, good to meet you, and I try to understand something when you speak slow.
Okay, thank you. Muito obrigada pela palestra. É uma palestra realmente rica de informações, rica de detalhes, de casos, de direito comparado, principalmente. Acredito que é importante para nossos alunos e alunas olhar para diferentes aplicações do direito, no caso, na área do fashion law. Marlena, I have just a question for you. I have a research group here in Mackenzie that studies digital law, mostly in the labor law, but in the other areas too. So do you have any, can you speak a little bit about fashion law in the metaverse? Because I saw in Italy is a debate in the moment. Brands like Gucci, Armani are in the metaverse doing business with the brand. So that is my question, and parabéns mais uma vez pela palestra.
Should I answer right now or wait till all the comments come in? Or all right, so I was just looking, okay, and waiting. Obviously, right. So this is quite a phenomenon. Watching this intersection between the traditional approach to law and digital law and technology law, and really looking in astonishment what's going on, as we don't understand much. And even technology law, which I find fascinating, is like quite sort of a bastard. It's like a child of like born from unmarried couple, so to speak, because we have public law and private law, and there's like lots of at the crossroads, so to speak. So that is one thing. And when it comes to metaverse, it is quite a deep problem, because it's also about the digitalization of any sort of web on all these designs. And here it's we call it actually also wearables, or it's like a digital fashion, so to speak. So obviously it is so that a user doesn't buy a physical good, not a dress, but just a good image. So that even here in Teams, I could be wearing like Gucci Prada myself, which is not not a physical Gucci, but it's only something that is shown here in the image. That's what it is. So here's a question: how do we actually qualify this image? Is it a work of authorship, and what sort of work of authorship that is? Whether that is with fashion design again, or is it like pictorial representation or digital work? So especially that it can behave in many different ways regarding this very digital surroundings, so to speak. And then as much as copyright is at stake, we have to acknowledge that copyright law happens, so to speak. I mean, is acquired ex facto creatio, Latin. So like a mere fact of creation involves their protection. So let's say it makes it easier, but in fashion still, copyright law is less acknowledged. Fashion is more about it's about trademarks and about obviously industrial designs or patent designs under the US law, if you will, and these come at a registration. And obviously registration is based on the territorial rule, meaning that you can register each of these in separate countries unless you go to WIPO in Geneva and you acquire a global protection. But again, what sort of protection do we have in the internet? In the internet scenario, between it goes beyond any territory, and obviously this is one of the issues that will have to be investigated. So again, there's lots at stake. Obviously, this is the very moment when lots of brands can make a lot of money, and the bottom line, so to speak, like the financial performance can be amazing, but still, if they don't go for the rights and don't really present a strong IP policy themselves, they can miss out on an opportunity to adjust and again be in that fashion business. So lots at stake, and obviously from here I could depart in many directions, but I just want to say, and I think that's like super important, because we don't really have many books for that, and I'm advocating for this myself, which is I would like to depart at some point from intellectual property law as we know it, because that is a kindergarten, and I'm sorry for saying this. It's like I'm a lover of intellectual property policy. So what do you really do with everything you know? It's like, obviously, it's like in business. You can know all the economies, all the economics, but then you need to make money for your company and be the rainmaker. So again, by example of Christian Louboutin, that was so much anxious about his red-colored sole, and finally, as much as they couldn't really obtain copyright protection, but they have actually some of the verdicts actually in their favor, that it could be actually a trademark for the red sole itself. I'm just giving you a very basic example of how much it takes to stand your ground in intellectual property and actually create new or created anew that's another issue. But I guess many fashion brands, especially Italian ones and also French ones, let alone also Brazilians, they have great legal counsels, and it takes absolutely prominent lawyers to switch on their creativity and fighter's mode and create something that has not been there yet, even though we have to go beyond our very theoretical premises of copyright law or intellectual property law. So that would be my point. But that's a good one. I think I should write a paper on this. Yes, I should explore it more.
Good. Thank you very much, Marlena.
Thank you.
Pessoal, eu estou à disposição aqui para poder mediar as perguntas ou as indagações de vocês. Como a professora Nora escreveu no chat, pode ser em português, pode ser em inglês, não tem problema. Perfeito, a professora Fátima levantou a mão. E o professor Manelo também. Isabela também, por favor. Então, vamos começar pela ordem. Isabela levantou a mão primeiro. E depois a professora Fátima. Isabela, você está com a palavra.
Thank you very much. Obrigada, Francesca.
O seu microfone está um pouco... faz um ruído.
Vai dar microfonia aqui, porque a gente está na mesma sala, não tem jeito. Dá para ouvir assim mesmo?
Ok, dá para ouvir.
Não tem como resolver.
Ok.
Obrigada, desculpem. Em primeiro lugar, bardzo dziękuję. So I try to say thank you very much in Polish.
No, bardzo dziękuję. I shouldn't hear that. You have a good accent. Yes.
Yes, thank you.
Thank you.
It was Google Translator, so but thank you very much. It was a very, very inspiring conference. I'm not so used to I'm not a lawyer yet, but I saw that in fact the questions that are put in fashion law concerning originality and level of individuality or Neuheit are very interesting, and also a part of if I understood well, of a larger reflection on originality in arts in general. I could recognize in your very rich examples and discussion of jurisprudence and theories some tendencies that we can observe in the discussion of originality and plágio in Portuguese, in concerning intellectual works. For instance, when you mention Barudi's theory about the importance of taking into account creative decisions, yes, not only we can that the creative decisions should be the basis of the role of individuality and not the contrary. This remembers very much the discussions on intention that are very close to very important to romanticism. The original, measurement of the originality of a work depends a lot of the intention of the author in romantic theories of literature, for instance. And on the other side, when we focus on individual affections, not in individual elements, but in an overall impression of the product, if this overall impression, if I understood well, is the tendency now in German jurisprudence. We are focusing not on the original elements, which singular originality of each singular element, but on the originality of the disposition and the arrangement, new arrangements of the elements. And these how can I say, these roles or these tendencies are very close to what we call in theory of literature and arts there is the intertextual theory, which had a lot of influence of French theoreticals or of, for instance, Bakhtin and his readers in French. So what I'm trying to say is that maybe we can see that in discussion of fashion law, how these larger theoretical discussions on the nature of what's new in art, new in comparison with which it's always a relative concept, isn't it? What's new? It's new in relation to something that's not new, and how long and for who. So in practice, I found it very, very interesting, the question of time when you showed us the example of Chanel, which is atemporal, and that's why we have so much cases, problematic cases on the imitation of Chanel and things like that. And a question I would have in this sense is about, how can I say it in English? We are saying, so what I was trying to say, what's new in comparison with other things that exist, with other creations, and how long, and you showed us this seasonal component of the legislation, but to which point, my practical question in this sense would be, to which point the international standards, the international creations are considered, for instance, in German law or in USA. So which are the parameters in terms of nationality, or is there, do you think that it's reflected also in the jurisprudence or not? So there is a larger commentary in which I wanted just to show you how much for me, your presentation dialogues with a larger theory of originality, and which is not consensual too in terms of only theoretical aspects, and a question about the international standards of the originality in jurisprudence. Just a third remark, if
Thanks, Isabella. Probably we could give some time for Professor Marlena to answer this question, and then we come back. We have other people that ask for the floor,
Okay.
and we can ask. We can come back to you. Thank you,
Okay, thank you very much.
Isabella.
All right. Let me answer these questions. I'm sorry. I guess my teams got confused a little bit and started changing not only different slides but also presentations across my computer. First off, Isabella, I wanted to thank you for this remark. That is truly important, especially for those that are not lawyers here or not even lawyers or like have a multiple specializations, because indeed this romantic approach, that is something that is right at the core, at the heart of copyright law. However, we don't exercise these premises anymore because in order to establish copyright law, it had to be somehow introduced, and it took a lot of, I would say, psychological but also philosophical arguments. And one of the psychological argument was that romantic approach, romantic authorship. So back in the day, talking about there will be the 18th and 19th century back in Europe, with all these revolutions and uprisings. And I don't know if you know of the so-called Spring of the Nations. It goes back to 1848. So it is more or less the time when the whole Europe was in fire, and all these all that social strata and social class of Europe went like upside down, because back in that social strata there was no place for authors, for creators or such. So philosophers and writers like Goethe and many others tried to advocate for this specific protection. And I thank you, Isabella, for this, because it is important to stress that originality and individuality that I'm discussing here with you, that is a very legalistic, so to speak, concept. So if you open all these beautiful books on theory, especially on poetry, especially theory of poetry, theory of literature, of arts, and so on, or music, you won't find lines with copyright law theory. So this is something that I always stress as well, that we have our own legal understanding of originality, which is built on legal theory and then practiced in jurisprudence as well. So here you have to be very careful and quite sensitive about the boundaries. I don't know how much time I have, but apart from all these theories that I already mentioned, but there's one theory that is actually exercised also in the US law, and that is theory of communication, which is Claude Shannon. And the theory of communication, that is something on which many sciences were built, including communication alone, psychology as well, and computer sciences. So it's about communication. So let's say we have a source of information, then we have a sender and receiver, and between these two there is a message. So that's the communication part. But you can also think of copyright law from this perspective. So let's say if I'm painting a picture, that is what I see is my source of information. I become not only an author, but also a sender of information, which is conveyed to my audience, let's say readers, listeners, in this little box called work of authorship, but that is also a message itself. And as beautifully as it works for, I would say, music and pictures and even literature, I believe it is quite difficult to apply to fashion, for instance. So all these theories, like individual creation, selection, choice, and overall impression, they are not always transferable from one kind of a work to different kind of a work. So here's another constraint and another problem. And I would say that as much as I don't really have time for this, I have to say sadly that we have many different levels of originality and many definitions, sub-definitions of originality from court to court, as I believe our human brains are quite limited and we understand many concepts differently. And this human factor can be really observed across all these, I would say, national, domestic, or even international cases. So the mainstream is the perfection, so to speak, but we still would find some quite provocative regulations or rules, rules and decisions that don't really fit the model. I could really say more, but I think that would be it. Like, yeah, just to keep it concise.
Thank you very much.
Thank you, Isabel.
We thank you a lot for your questions, for your provocation, Isabella, for already thinking about this issue. And thank you a lot, Professor Marlena, for showing us how this interdisciplinary discussion is important, not only regarding law and other fields of knowledge, but also inside law, bringing us how many details may be important if you're thinking about legal protection. I would have seen that Professor Romanello and Professor Benedita, if you want to say something, you have the floor, and then Professor Romanello.
Professor Nora, I think Professor Benedita is not here, and Professor Romanello is logged on in the account of Professor Benedita. I don't know.
Se abaixo, se eu vou subir aqui, né? Você sabe onde é? Okay. Thank you very much for this opportunity. Thank you, Marlena, for your excellent and marvelous speech. Just to know, Professor Isabella is a law student, but she is a postdoctoral in classical languages, and she's specialist in Latin, okay? Professor Nora is postdoctoral also in law, and Professor Francesca Colombo is postdoctoral also. She was born in Italy. She's from Sardinia, if I remember well, and she studied at Tor Vergata in Rome. Well, my question, perhaps you when you hear my question, perhaps you say, well, this is very easy, or this is perhaps not to even ask about, but that amazed me when you spoke. You said that fashion law is considered an art, a concrete creative dress, for example, a suit, and art is copyrighted, protected. When this artist dies, like for instance Versace, I would like to know in Poland, France, Germany, Italy, or Holland, here in Brazil, his art when he dies, goes to the son, to the family, you know, I mean, money. So, here it's about 70%, 7 years after the death, this copyright protect is still on. In these countries, is it the same? Or at least in Poland, 70 years or less or more? I don't know. That's my question.
Thank you, Professor. You triggered actually another point that I would like to make just after I answered your question. Yes, it is 70 years, and obviously, as for economic rights, but apart from economic rights, we also have moral rights. These are unending and unwaivable and perpetual, so to speak. So as for authorship or integrity, and that is something that is strongly kept by an author and his family and anyone else that would many years and even decades after his death would still feel like they want to protect and keep hold of this relationship between the work and the author himself. Obviously, here in the legal, here in Europe, we have two legal strains, so to speak. So the French one, the Roman one, and also the German one, Germanistic. So the one that I'm telling you right now is more Germanistic, and we're obviously in Europe, as Francesca would know, that we have actually these two strong influences, and many countries actually are influenced either by Roman or by Germanistic, and then we kind of choose which is better, given all the circumstances, social, psychological, economic, etc. So the Polish copyright law was based on German law, and again, there's a strict distinction between economic rights and moral rights. So that's the so-called dualistic approach. But there's also, so that's actually the other way around. The German is actually monistic approach. So we were influenced by French. So French is dualistic approach, saying that there is a strict distinction between economic and moral, and I don't really quite remember how's Italian law drafted, but let's say Switzerland is also an example of one of the countries that had quite a battle whether to choose more Roman approach, this dual approach, or monolithic approach, and this monolithic approach was is actually practiced in Germany. So according to this one, economic rights and moral rights, they are like somehow merged together. There's a very strong interplay between all these, and Professor Ulmer, another great German professor and philosopher, he came up with this idea of a tree, meaning that right at the roots we have moral and economic, and they are like somehow joined together at some point, and then at their branches we have all these leaves and flowers, so to speak. But these are like this is an outcome of something that is strongly interconnected, that is both economic and moral, and you cannot easily distinguish between something that is monetary, meaning economic, and non-monetary, meaning moral. And there you cannot transfer rights, you only license them, and that is again 70 years after one's death. However, you cannot transfer copyrights, and at some point the definition, the protection lapses after 70 years. But here's another issue. So as a matter of fact, I would agree with you, but in general it is similar. In specifics, there's lots of detail to it. So obviously in law everything gets complicated with certain level of complexity. But here's here's another one that I'm also studying partly. How is it so that we have these great designers, as you say, like Versace or Coco Chanel, and they have their own rights, which they acquire, obviously, but there's a vision that comes with the rights. So obviously, when talking about big painters, big famous musicians that are deceased and their families, quite often it is argued in courts that the family does not support the author's idea. So quite often it is so, if you have noticed this as well, that an author himself is very open to any sort of copying, any sort of, I would say, using, it's like using his work with his sort of authorization, but against no remuneration, no license fee. So we had quite a few cases, quite I would say quite famous cases in Poland regarding musicians, etc. People of arts in Poland, as widows and children wanted, pursued a very strong protection, policy. However, the author himself would not wish for that. And here, look at, let's say, I would point at Coco Chanel, that was very open towards any sort of copying, and even herself, it was herself that said that she would rather see women having copycats of her bag than having cheaper originals of other brands. And as much as she had her circle of clients, she was super open to having everything copied from her, because she was a visionary, and she kind of knew she can come up with so many ideas like this. She wasn't really afraid of a competition, and especially copying. And she said, yeah, sure, because this is Paris and we set the trends, so you guys copy all around the planet, and this is how I maintain my super high position. And then back to La Maison de Coco Chanel, obviously, it has all changed with these new designers, and especially these days, as it's all about the revenue and the very strong protection of whatever you will, as a logo, as a design itself, and I guess that's what it is. And one topic that I was planning to study a little bit harder, that is actually succession of copyrights of designers, what happens later, because legally speaking, but it's not only law, it's also some sort of business practice. You have to differentiate also between family houses like Versace or Gucci or few more, even Louis Vuitton at some point, and these very corporate fashion houses. And it is quite so that at some point, once the visionary, the true originator dies, and there's nobody to keep it rolling after his death, it is all bought out by these big corporations, and then the policy changes. So to give you an idea, Versace, House of Versace still is one of not many houses that, despite huge legal and financial troubles, did not let itself sell to big corporation, just to become just a name, but without any contents, really, no body inside. Another example would be Tommy Hilfiger. So obviously, I studied his history because it's always fascinating. But at some point when he was, I don't know, 70 something, he said, "Oh yeah, I've made so many millions in my life. Now I can take a step back." And he sold his empire to corporation, and now he's just a face person. So that is, I would say, super complicated, but again, this is why you need to impose this economic view upon legal perspective only. So again, law not in action is not worth much.
Thank you very much, Professor Marlena. So I think this meeting contributed for our next article of yours for our next book, Law, Fashion Law and Succession. Thank you.
Maybe TV series this time, obviously. I'm just joking, like too many books on our hands, as you know it. Yes, thank you so much.
Thank you.
Professor Nora, anybody wants to do more questions? Or maybe we can finish. So I
think that I saw that Professora Benedita has just arrived, and I wonder if she wants to say hello or say something.
Professora Benedita, você tem a palavra, caso queira falar alguma coisa, nós podemos traduzir.
Conseguem me ouvir? Está dando microfonia. Pronto. Muito obrigada, professora Marlena, por estar conosco aqui, por ter aceito o convite do professor Romanello. A gente agradece muito. Professora Francesca, professora Nora também, que prontamente atenderam ao convite para serem mediadoras, Daniel também do cerimonial, professor Romanello. A gratidão pela contribuição com a academia, com essas novidades no direito, que não só no Brasil, como também no exterior, discutir essa questão do direito autoral, discutir essa questão do que é criativo, do que é criatividade, do que é o novo. Essa discussão também que afeta a moda, está muito ligada também à questão do clima, né, do quanto ela vai impactar o meio ambiente. Então, são questões muito importantes e que a sua palestra veio a colaborar muito, né, com o nosso entendimento, e eu sou muito grata à professora e a todos.
Okay, so just to sum up, Professor Marlene, I hope you have understood, but there
yes,
was
I have a lot, actually. That's why I love Brazilian Portuguese, because it's easy for me to understand. And we also have all these vowels like sh and sh. So it's easy for me to learn this language. And também muito obrigada. And I really hope that next time I'll speak longer and more rounded sentences. But thank you, Professor Benedita, and also Professor Nora, for all your support, and especially Professor Nora for your help and guiding me through before this presentation. And again, many words of thanks to all of you for having me, and especially Professor Isabella as well, for including interdisciplinary remarks, because that's what fashion is about. So I'm very comfortable here sitting with you discussing, which is so amazing, and so thank you so much.
If you do not mind, I will give you some final remarks, and then I will give the word to Professor Francesca to make the final words. Of course, we are very amazed and really thankful. It was an honor. It was really, we very much appreciated your presentation. We very much appreciated the topic, the importance of the topic, and how you managed to show us how this international and global approach is important, not only regarding the discussion of German law, but this international approach that has come for us, not only because we are in a global world, we are in different places. You are very generous to be in at night in the very, very blue hours, be present with us. Technology has helped, of course, with this, but for showing the importance of this topic, for showing us how law protection is important. And we are very sure, as Professor Romanello mentioned, we are very sure that we will follow up with this conversation. Finally, I would like to add some thank you and how amazing we are with your depth of your presentation, of your topics, and for your enthusiasm that has really been accepted and received by us with a lot of happiness. So we hope we can repeat or try to continue or follow up with this discussion. And then I give you the word for my colleague, Professor Francesca, if you want to give your final remarks so that we can close, and hope that we keep in touch.
Now, just to say thank you one more time, and obrigada também aos colegas que nos convidaram e fizeram com que eu e a professora Nora fôssemos incluídas neste momento tão interessante, nesse debate tão profícuo para a nossa universidade. Eu quero agradecer à professora Benedita, quero agradecer à professora Isabela, ao professor Romanello, quero agradecer o Daniel também, porque nos permitiu conduzir este debate. Mais uma vez, obviamente, obrigada, professora Marlene, e espero vê-la um dia pessoalmente aqui no Brasil, em Campinas, na nossa universidade. Você está super convidada para um dia pessoalmente nos brindar com mais instigações, né, e mais indagações. Thank you very much. Devolvo a palavra à mesa, pessoal.
I would just add, if I may, but I was really saddened and nearly heartbroken, but I cannot show you pictures. As I was also studying with professors French law and Italian law, as a matter of fact, and also the law of the Netherlands, and we also had some cases from Poland with the files. Original files and some pictures to it. So at some point I'll be also offering some sort of extra talks about fashion design, but with pictures. So I will obviously let you know through Professor Romanello, because this is gonna be a real fun, not just like talking like a very legalistic, like sitting and talking, discussing, but also watching and really interpreting, but real pictures. Yes.
Excellent.
Thank you.
I would like to thank you, Professor, and thank all other professors that are here. This presentation is only possible thanks to the professor of the University of Mackenzie. So I would like to thank you in the name of the all University of Mackenzie. Thank you, Professor Marlena. So if anybody wants to talk, or want to do more questions, or maybe we can finish the presentation. Professor Nora, anything? So, once more, I would like to thank you, Professor Marlena. E para todos os demais presentes também gostaria de agradecer, e também convidamos todos para o evento que acontecerá à noite. Às 19 horas hoje teremos o debate do papel na tradição luso-brasileira na recepção de teorias estrangeiras, com o Dr. João Carlos Metalache. E às 8 horas da noite, teremos os aspectos centrais da moral e da doutrina do direito de Kant e sua presença no discurso jurídico brasileiro. Às 21 horas, teremos a interpretação jurídica segundo Savigny, com o Dr. Eduardo Henrique Albert. Novamente, agradeço a todos, conto com a presença de todos à noite. E once more, Professor Marlena, thank you to be here.
Só uma coisinha, a professora Marlena está na Austrália, agora é 1h da manhã lá. Professor Marlena is in Australia now, it's 1 a.m. So have a nice sleep tight.
Thank you. It's not a problem, as I'm a night person, and it's really lovely joining Brazil, and I'm really thankful to MS Teams that we can do that, and I don't need to spend hours on plane. So